All right, good morning. The court is going to take up cause number 988, which is a Reynolds County case. This is in the interest of Aspen Knopp, a child. The case is set for a bench trial today. The trial is being conducted pursuant to emergency orders of the Texas Supreme Court via Zoom video conference. Participating in the trial today on behalf of the department is caseworker Evelyn Ivy, Supervisor Crystal Gillette, and Regional Attorney Christine Rankin. The mother of the child is Julian Knopp. The court take judicial notice of the court's file to the extent it reflects that Ms. Knopp was personally served with citation notice of suit on September 15, 2020, as reflected in the officer's return filed on that same date. The court further take judicial notice of the court's file to the extent it reflects that after being personally served with citation of notice of suit and with the petition, Ms. Knopp has not appeared at any of the hearings set in this case. She has not appeared for the trial set in this case. No attorney purporting to represent her has entered an appearance in the case on her behalf, and she has not filed with the court any request for a court-appointed attorney, and she's wholly in default. There is a respondent unknown father named in the department's pleadings who was cited by publication through posting on February 23rd, 2021, as reflected in the officer's return filed with the court on March 1st, 2021. The court has appointed Tom Davidson as attorney ad litem for the unknown father, and Mr. Davidson will be joining us here just momentarily. The attorney and guardian ad litem for the child is Jessica Skinner. Ms. Skinner is not present in the courtroom at this point, but should be joining us here just momentarily. I think she's tied up in another court, so she should join us here shortly, and we can begin. The current caregiver for the child is Patty McCluskey, and Ms. McCluskey is participating in the trial today. The court is going to excuse from participation in the trial today the child that is the subject of this suit. As I noted, we're sitting here on a bench trial. Ms. Skinner has advised she should be joining us here in just a few minutes, so I'm going to take a short recess until she's able to join us, and then we'll get started with the hearing. So I apologize for the delay, but if y'all can stand by, as soon as she joins us, we'll get going. All right, thank you. We'll be in recess. All right, I'm going to go back on the record and cause number 988. This is in the interest of Aspen Knopp, a child. Um, all parties in council previously present remain present, I believe. Ms. Rankin, are you back with us? Y'all stand by. I'll note Ms. Jessica Skinner is now with us as attorney and guardian ad litem. I'm waiting for Ms. Rankin to reconnect. I think her connection dropped off for a moment. Y'all stand by.
Judge Banks, Christine just let me know that she's trying to reconnect. So,
All right, thank you. I'm waiting. Sorry for the delay to the rest of you participants. Hopefully Ms. Rankin can, I think she may be having a connection issue, but hopefully she can join us in a minute when we get started. All right, as indicated, we're back on the record in cause number 988 in the interest of Aspen Knopp. All parties in council previously present remain present. And Ms. Rankin has been able to reconnect with us. The case is set for a bench trial today. Ms. Rankin, is the department ready to proceed?
Yes, sir. Department's present, ready.
And Mr. Davidson, are you ready to proceed?
We're ready, Your Honor.
And Ms. Skinner?
Ready, Your Honor.
Okay, and as noted earlier, the respondent mother was personally served with pleadings in the case, and she has not appeared at any hearings in the case and not made any requests for counsel, and no attorney purporting to represent her has entered an appearance in the case on her behalf. The court's going to proceed with the trial. Is anybody invoking the rule?
No, sir.
The rule is not invoked. Any opening from the department, Ms. Rankin?
No, sir. Department waives opening.
Waive
Mr.
opening, Your Honor.
Okay. Ms. Skinner?
I'd waive, Your Honor.
Okay, thank you. All right, Ms. Rankin, if you're ready to proceed with your first witness.
Thank you. Department calls Evelyn Ivy.
And I'm going to ask Miss Ivy and Miss McCluskey, in case she calls a witness, if y'all would both raise your right hands, please. Do each of you solemnly swear or affirm any testimony you give today before the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. All right, Mr. Rankin, if you're ready then.
Thank you. Can you state your full name?
Evelyn Ivy.
And are you the to engage caseworker for Aspen Knopp?
Yes, ma'am.
How old is the child?
She is 10 months old. Sorry. She just turned 10 months old.
Okay. And can you explain the circumstances of her birth?
She was born and she tested positive for methamphetamines. The mom also tested positive during her birth, and she was removed from the mother at the hospital.
Okay. What admissions, if any, did the mother make regarding her meth use at the hospital?
She and I'm not sure she admitted to using 2 days prior to giving birth because her teeth were hurting, as mentioned in the affidavit and the reason for removal.
Okay. And what did she admit to using? What substance?
Methamphetamines.
Okay. And at the hospital, when she appeared to give birth, did she exhibit any signs of recent or current methamphetamine use?
Yes, the nurse at the hospital stated that when Miss Knopp came to the hospital to deliver that she was high and she had been twitching. And also when I picked up Aspen to place her from the hospital, they had mentioned that while the mom was there, she began to withdraw and have withdrawal symptoms. They kept Aspen extra time in the nursery to make sure she did not have withdrawal symptoms as well.
Okay. And this is not Miss Knopp's first child, is that correct?
That is correct.
And it's not the first child the department's removed from her care, correct?
That is correct.
The child that she had just before giving birth to Aspen, was that child also removed by the department and eventually parental rights to that child terminated?
Yes, ma'am, that's correct.
Okay. And Aspen Knopp has approximately 8 siblings, correct?
Yes, as to my knowledge from the investigator.
Okay. Are any of the siblings or any of the children that Ms. Knopp has in the respondent mother's care?
No, ma'am, to my knowledge, they are not.
Okay. Did you file a family plan of service in this case?
Yes, ma'am, I did.
Did she participate in that family plan of service?
No, ma'am, she did not participate in the initial permanency conference.
Okay. But the services were court ordered for her to complete?
Yes, ma'am.
Of the services ordered for her to complete, how many, if any, did she complete?
She did not complete any of the services that were ordered.
Okay. When is the last time you've seen the home to see if it's appropriate for a child?
I have not been able to make home visits. I've repeatedly asked Ms. Knopp for an address, and she will not give me an address. So I have not been able to locate her. I've done Vine searches as well, and it does not show that she is currently incarcerated either.
Okay. So when's the last time that you've had any contact with Ms. Knopp in person?
I have never had any contact with Ms. Knopp in person.
Okay. When's the last time you've had a phone call with her?
I had a text message a couple of weeks ago. I text her monthly to repeatedly ask for an address or any contact with her to get her back working services or anything. She'll sometimes respond a couple of days later, sometimes it's weeks later, sometimes not at all. It's very sporadic and not anything substantial.
Okay, so when is the last time she actually responded to one of your texts?
It was June 28th.
Now, the child's had several medical visits, well child checkups.
Yes, ma'am.
Okay, of the visits, of the well child visit, medical checkups that this child has had, how many has the respondent mother attended?
None.
Has she ever called to see how the visits went, or how the child's health was?
No, ma'am.
When's the last time that this respondent mother has had any type of in-person or virtual visitation with the child?
We set up her 5-day visit virtually on Zoom due to Miss Knopp having a C-section, and she was not able to drive to the Brownwood office. And that was the only visit she attended. After this first initial Zoom visit, those were set up for Friday mornings at the Brownwood office. And she never confirmed her visit the day before like we asked, and she never attended any visits.
And has the child been in the department's care for at least 9 months?
Yes, ma'am.
Has the mother provided any type of in-kind or monetary support for the child?
No, ma'am.
Is to engage requesting that this court terminate the parental rights of Julian Knopp as to Aspen?
Yes, ma'am.
And do you believe this is in the child's best interest?
Yes, ma'am.
Why do you believe so?
I believe that Aspen is in her current placement, and that is her best interest. Jillian has failed to remain in contact with the department and failed to work her court-ordered services. I can't approve a home that I haven't seen without an address. So I believe that it is her in Aspen's best interest to have Jillian's rights terminated. Yes, ma'am.
And have you received any notion from this mother that she wishes to even parent this child?
No, ma'am.
Pass the witness.
Ms. Skinner, do you have any questions?
Yes, Your Honor. Where's the child currently placed?
She is in a foster home with a foster mom in Rising Star.
And how is she doing in her foster placement?
She is thriving. She's doing very well. She's meeting her milestones. She's very bonded with her foster mom. I've observed their interaction. She's always smiling, laughing. When you talk to her, she smiles and lights up. She's just a very happy baby and very on developmentally target.
Do you have any concerns with the foster placement?
No, ma'am, I do not.
I'll pass the witness.
Thank you, Mr. Davidson. Any questions?
Your Honor. Ma'am, I represent the unknown fathers in this case. Have you ever had any discussions with the mother of the child about who the male parent of this child could be?
Yes, sir. I've asked her through text message several times who the father could be, and she's never answered the question. If she responds back, it's usually another, just like avoiding the question. She doesn't directly answer the question.
Sorry,
You're
Mr.
muted.
Davidson, I think you're muted.
I'm sorry, Your Honor. I was on temporary unmute. So there's no way for me or you or anyone else to determine who the actual father is of this child without more information.
That's correct.
Pass the witness, Your Honor.
Ms. Rankin, other questions for Ms. Ivy?
Is the department requesting to be awarded permanent managing conservatorship of the child in order to facilitate an adoption?
Yes, ma'am.
The child has 8 siblings. Will this child have contact with its siblings?
I haven't been given, oh, sorry. I haven't gotten any family information on the siblings. I've looked in impact. So I can talk to Ms. McCluskey, the foster mom, about seeing about sibling visitation. But that hasn't been set up previously.
Did the child that was terminated before Aspen, was that adoption facilitated through the department?
To my knowledge, yes.
Okay, and where is that child placed?
I believe it's in Gillespie County. I don't know what city it's in, or the child's in, or the home is in. But I can do some research and find out.
Ask the witness.
Any other questions, Ms. Skinner?
No, sir.
No, Your Honor.
Mr. Davis, any other questions? Ms. Ivy, the department try to locate any relatives, the child for possible placement?
Yes, sir. I looked in our system, and I did contact one of the previous dads on a previous case that has the two of the siblings of Aspen. He told me that most of Jillian's family lives around the Fredericksburg area, and that he thought that they all were on using drugs, and he hadn't seen Jillian in a few years. He did give me her sister's name, and I looked her up in Impact. He didn't have a phone number, and I tried to call that number that I found in our system, and I didn't receive a response. It just was a non-working number, and that's all I really had to go off of without any information from Ms. Knopp.
So is your testimony today that the department has not identified any appropriate relative placements for the child?
That's correct.
Thank you. All right. Unless there's any other question for this witness, Ms. Rankin, do you have a witness you want to call?
No, sir, the department rests.
All right. Ms. Skinner, did you have any witness you want to call?
No, Your Honor.
Davidson, any witnesses? None? Okay. All right. All parties rest and close them.
Yes, sir.
Any closing from the department, Ms. Rankin?
Department's requesting termination of parental rights as to the unknown father and the respondent mother. We believe this is in the child's best interest, and this mother has shown no desire to parent this child whatsoever in the almost year that this child has been in the department's care.
Thank you. Mr. Davidson, any closing?
Your Honor, we concur with the department and Ms. Rankin. The mother has indicated no desire, and in fact, by omission, has indicated her intent, which is she wants nothing to do with this child. As the ad litem for a potential male parent, I would certainly want this child to be raised by somebody much more appropriate as a parent than the biological mother. Thank you, Your Honor.
Thank you, Ms. Skinner. Any recommendation as attorney and guardian ad litem?
Judge, we're in agreement with the department that parents' rights should be terminated and the placement continue.
All right. Thank you. All right, if you'll stand by for just a second. All right. The court, pursuant to Chapter 201 of the Texas Family Code, after hearing the evidence presented and after taking judicial notice of the court's file in this case to the extent permitted by law, including specifically the certificate of paternity registry search dated April 22nd, 2021, filed with the court on March 27th, 2021, that reflected no person claiming to be the father of the child has filed any notice of intent to claim paternity of this child. And after hearing the recommendations of the attorney and guardian ad litem for the child, it's going to make the following findings and then the following orders. The court finds that a request for identification in the court of continuing jurisdiction has been made as required by law, and no other court has continuing exclusive jurisdiction in the child, and this court has jurisdiction over this action. The court finds all parties entitled to notice have been notified. The court finds that any presumption that the respondent mother or the respondent unknown father should be appointed as a joint managing conservator or as a sole managing conservator of the child is rebutted, that the appointment of the respondent mother or any respondent unknown father of the child as a sole managing conservator, as a joint managing conservator, or as a conservator with the right to designate the primary residence of the child would not be in the best interest of the child because such appointment would significantly impair the child's physical health and emotional development. The court finds that the appointment of the respondent mother or the respondent unknown father as a possessory conservator of the child and awarding them rights of possession and access to the child would not be in the best interest of the child because such possession and access would endanger the child's physical and emotional welfare. Any presumption that they should have rights of possession and access to the child pursuant to the standard possession order is rebutted. An application of the standard possession order to the facts and circumstances of this case is unworkable and inappropriate, and that a denial of rights of possession and access to the respondent mother and the respondent unknown father do not exceed those limitations that are necessary to protect the best interest of the child. As to the respondent mother, the court finds by clear and convincing evidence that the respondent mother knowingly placed and knowingly allowed the child to remain in conditions or surroundings which endangered the physical and emotional well-being of the child within the meaning of Section 161.001B1D Texas Family Code. The respondent mother engaged in conduct and knowingly placed the child with persons who engage in conduct which endangers the physical or emotional well-being of the child within the meaning of Section 161.001B1E Texas Family Code. The respondent mother failed to comply with the provisions of a court order that specifically established the actions necessary for the respondent mother to obtain a return of the child, who has been in a temporary managing conservatorship of the Department of Family and Protective Services for not less than 9 months as a result of the child's removal from her parent under Chapter 262 Texas Family Code for the abuse and neglect of the child within the meaning of Section 161.001B10 Texas Family Code, and the respondent mother has failed to prove by preponderance of the evidence that the respondent mother was unable to comply with the specific provisions of the court's orders and that the respondent mother made a good faith effort to comply with the court's orders, and the failure to comply with the orders was not attributable to any fault of the respondent mother within the meaning of Section 161.001D Texas Family Code. The court further finds by clear and convincing evidence that the respondent mother constructively abandoned the child who has been in the temporary managing conservatorship of the Department of Family and Protective Services for not less than 6 months. The department has made reasonable efforts to return the child to the respondent mother. The respondent mother has not regularly visited or maintained significant contact with the child, and the respondent mother has demonstrated an inability to provide the child with a safe environment within the meaning of Section 161.001B1N Texas Family Code. The court finds by clear and convincing evidence it's in the best interest of the child for the parental rights of the respondent mother to be terminated pursuant to the foregoing sections and Section 161.002B2 Texas Family Code. As to the respondent unknown father, the court finds by clear and convincing evidence that the respondent unknown father, after being served with citation, did not respond by timely filing an admission of paternity or a counterclaim for paternity under Chapter 160 Texas Family Code within the meaning of Section 161.002B1 Texas Family Code. The child, the subject of the suit, was under 1 year of age at the time the petition for termination of the parent-child relationship was filed, and the respondent unknown father is not registered with the paternity registry under Chapter 160 Texas Family Code within the meaning of section 161.001B3 Texas Family Code. The court finds it's in the best interest of the child by clear and convincing evidence that the parental rights of the respondent unknown father be terminated pursuant to the foregoing sections and section 161.002B2 Texas Family Code. The court finds by clear and convincing evidence that the court's findings under section 161.001B Texas Family Code and the order of termination of the respondent's parental rights is not based on evidence precluded from consideration by the court under section 161.001C Texas Family Code. The court finds it would not be in the best interest of the child to appoint a relative or other person as permanent managing conservator of the child, and that it would be in the best interest of the child to appoint the department as permanent managing conservator of the child and to continue the child in the current placement pending further order of the court. The court finds by clear and convincing evidence that the following orders are in the best interest of the child. It's ordered that the parent-child relationship is terminated between Julian Knopp and the child is subject of the suit. Any parent-child relationship between the respondent unknown father and the child is terminated. The department is appointed as permanent managing conservator of the child with all the rights and duties of a non-parent permanent managing conservator under applicable law. Current placement of the child is approved pending further order of court. Tom Davidson is continued as attorney ad litem until 31 days after entry of a final order by the court reflecting findings and orders and judgment announced by the court today. Jessica Skinner will remain as the attorney ad litem and guardian ad litem for the child pending further order of court. And a permanency hearing after final order is set on October 19, 2021 at 9 a.m. The court gives notice to the parties and counsel of the right to appeal the court's findings and orders pursuant to section 263.405 Texas Family Code, and of the right to request a de novo hearing before the referring district court pursuant to section 201.015 Texas Family Code. The court gives notice that an appeal in the suit which termination of the parent-child relationship is sought is governed by the procedure for accelerated appeals in civil cases under the Texas Rules of Appellate Procedure, and that the failure to follow the Texas Rules of Appellate Procedure for accelerated appeals may result in a dismissal of the appeal. The court will enter an order of termination reflecting the findings and orders announced by the court today. Ms. McCluskey, thank you for everything you've been doing for this child in the past and everything that will be done for the child in the future as we go forward. Thanks also to the attorneys involved in the case and the department representatives. Unless anything else, we'll be adjourned for today. Thank you very much.